Justice DeWine currently serves on the Supreme Court of Ohio. His opinions reflect his strong belief in judicial restraint and his respect for the constitutional roles of the other co-equal branches of government. While on the court, Justice DeWine has helped move the Ohio Supreme Court in a more conservative direction. Justice DeWine has served at all levels of the Ohio judiciary. Prior to his election to the Supreme Court, Justice DeWine served for 4 years on the 1st District Court of Appeals, and prior to that, for 4 years on the Hamilton County Common Pleas Court. Justice DeWine has a strong commitment to furthering the rule of law through education. He is an adjunct professor at the University of Cincinnati College of Law, where he teaches appellate practice and procedure. In addition, he has taught undergraduate courses at the University of Cincinnati in Ohio Government and Politics and American Courts. Justice DeWine graduated from undergrad from the Ohio University in Oxford, and he graduated from the law school up north for law school. After law school, he was selected for a clerkship on the United States Court of Appeals for the Sixth Circuit. He served under the Honorable David A. Nelson, who had been appointed to the Sixth Circuit by President Ronald Reagan. Justice DeWine, before the bench, practiced law for 13 years with one of Cincinnati's top law firms, Keating, Munting, and Kleekamp. He represented clients in appellate matters in Ohio and in federal courts across the country. He handled a diverse range of litigation matters, including mass tort, bankruptcies, securities fraud litigation, and constitutional issues. Justice DeWine also was a county commissioner and a member of the Cincinnati City Council. Please welcome Justice Pat DeWine.
Thanks, Jebediah. I have to say I'm very excited to be moderating this panel today. It's an exciting topic for me for several reasons. First, because it really presents theoretical and practical questions that really go to the heart of our conception of the structure and the proper functioning of government. As core is about separation of powers, the proper role of each of the 3 branches. It also presents questions about judicial restraint and exactly how much interpretive authority the judicial branch should cede to other, theoretically at least, more democratic and more accountable branches of government. And it raises very real political questions about the expansion of the administrative state and the judiciary's role in the face of that expansion. Second, though, it's an area where there's a whole lot going on and a whole lot to talk about, and one where I at least have no idea what the future holds. As most of you are aware, the Supreme Court recently heard oral argument in the Kaiser case, a case that directly presents the question of whether the court should overrule what is known as our deference, the idea that a court should defer to an agency's interpretation of its own regulations. The court also recently heard oral argument in a less talked about case, but an interesting case, the PDR network case, which I'm sure I'm not quite sure what to make of, but I'm sure our panelists will, so I'll leave that to them. But as an Ohio State Supreme Court Justice, I would be remiss if I didn't remind everyone in the room, I think Judge Sutton left, but I didn't remind everyone in the room that not all law and not all decision-making is done at the federal level. And there's actually a whole lot going on in the deference area in our states. In the last year, Wisconsin and Mississippi have both completely revisited their deference doctrine and abandoned long-standing doctrines of deference to administrative agencies and replaced them with much more mild forms of deference. Here in Ohio, we have our own administrative deference theories. In the past, they haven't probably been as well developed or always as well followed as some of the federal doctrines, but they're out there. And the reality is, in some ways, we have even stronger forms of deference, because if you look at a lot of our past Ohio Supreme Court decisions, the Ohio Supreme Court has said we defer to interpretations of administrative agencies without even asking whether this statute or the regulation in question was even ambiguous, which is, takes out that first step that's so important in the federal context. I wrote an opinion last year that suggested that in another case, an appropriate case, we ought to take a look at our deference doctrines in Ohio. Justice Fisher, who's here. Justice Fisher, are you still here? Let me introduce Justice Fisher, who's my colleague on the Ohio Supreme Court. Justice Fisher joined that opinion. Two other justices wrote dissents, but they also suggested that they would be open to taking a look at our deference doctrines in Ohio. So for all you practitioners out there, that makes 4 out of 7 who've said we're kind of interested in this area and taking a look at it. So for what that's worth. We have a great panel today. Let me start with Aditya Bamzai, who's currently a professor at the University of Virginia Law School. Before joining the academy, he clerked for our own Jeff Sutton, so he knows Columbus. After that, clerked for Justice Scalia, worked at the Office of Legal Counsel, National Security Division of the Department of Justice. He's published articles on such diverse topics as the President's appointment and removal powers, and the Computer Fraud and Abuse Act, and he's written articles, the origins of judicial deference to executive interpretation and Marbury v. Madison, and the concept of judicial deference, one of which I read yesterday, which really provide a fascinating look at the historical development of judicial deference doctrines in the 19th and 20th centuries. We have Kristen Hickman is the distinguished McKnight University professor at the University of Minnesota Law School. She clerked for Judge Santel in the D.C. Circuit, worked in private practice for Skadden Arps. She's published numerous articles in administrative law. One repeated theme in those articles is that insofar as there's a problem with the expansion of the administrative state, it comes not so much from Chevron deference itself, but rather the broad legislative delegation of policy-making authority to agencies. Unlike some other scholars, say of Kantian influences on Bulgarian evidence law or whatever, her research has had an influence outside the academy. Her article, Chevrons Deference, for one, has been cited more than once in United States Supreme Court decisions. And finally, we have someone who I'm sure is familiar to almost everyone in this room, Chris Walker, currently a professor at The Ohio State University's Maurice College of Law. Professor Walker clerked for Judge Krasinski and then for Justice Kennedy. He worked in private practice and is part of the Justice Department's civil appellate staff. His research productivity is, to say the least, astonishing. I had one of my law clerks count yesterday, and he came up with over 35 articles since 2012. Can that be right? He obviously does not sleep. His research is usefully informed by empirical studies of judicial and legislative decision-making. This empirically minded outlook includes an important study of the effects of Chevron deference in constraining the political preference of judges and forcing judges to defer to the political branches on questions of policy. Let me open it up for them, maybe some introductory remarks from each, and at the end we'll leave time for questions from the audience. Well,
thanks so much, Justice DeWine, and thanks for all of you for being here. It really is an honor and delight for me to be here. And as Justice DeWine indicated, I've truly thought of Ohio and Columbus as a second home ever since I managed to sneak through the Judge Sutton screening process and find myself as a clerk here in 2004 to 2005. Hard to believe that it's been that long, but it's great to be back as part of this really vibrant and impressive legal community. So the topic that we're here to talk about, I probably don't need to introduce it in some ways because it's been so in the news, and some of my co-panelists are going to talk a little bit more about how this doctrine is being applied in the courts today. And what we thought we would do is I would speak a little bit with some framing remarks about how the doctrine evolved over time and how it got to the point that it's at right now. And so what we're discussing, of course, are the doctrine, sometimes now associated with the case of Chevron and Auer and Seminole Rock. And Chevron is the case that establishes that courts defer to agency interpretations to the statutes that the agency administers. Seminole Rock and Auer are cases about deferring to the agency interpretations of regulations that the agency has promulgated. And before I get into some of the maybe historical windup, I thought I would just step back for a moment and give you my big picture thoughts on this area, which maybe frame some of my perspective on how you get from point A to point B. And some of my big picture thoughts are that I'm not entirely quite sure what these cases stand for and what these doctrines stand for right now, today, and how exactly they're being applied in the courts. And so I, myself, I look at legal doctrines, rules of interpretation, and I think, how are we going to judge them? People sometimes ask me, students ask me, well, are these cases rightly decided? Is the doctrine being correctly applied? And I think, I don't know exactly what they are, for one thing, and the way that I would judge, are they rightly decided, are they being correctly applied as rules of interpretation, is whether the doctrine is predictable in some way, and whether the basis or source of law that establishes the doctrine actually does support the doctrine. And so let me talk about that for a moment, because the predictability angle, I think my old boss, Justice Scalia, really bought into Chevron as a predictable doctrine when it was first announced, because, at least superficially, facially, it has this two-step process, which is that we first determine whether an agency has directly spoken to a legal question, and then we figure out if if Congress has directly spoken to a legal question. And then if Congress has not, we figure out whether the agency's interpretation is permissible. And that's kind of the pure Platonic form of Chevron in the way that some folks interpreted it in the years immediately after 1984. And I think it's fair to say, and I'm curious to hear what my co-panelists' thoughts are, that as it developed, Chevron no longer really follows that two-step. And there's any number of cases over the last few years in which the Supreme Court has either just not applied Chevron and not explained why it's not applying Chevron, or created exceptions that fall under different doctrinal categories. So there's a major questions exception, there's a Chevron step 0, and without explaining what the technical rules are for these various exceptions to the doctrine, it all reminds me a little bit of, when I think back to how under the old Ptolemaic system, the scientists would explain how the planets revolved around the Earth, and there were just a whole number of epicycles upon epicycles that were built in to explain this observable scientific phenomenon. And I kind of look at the Chevron doctrine with its exceptions built upon exceptions, and I think to myself, well, just what's the basis? Like, where does all this come from? If we have a major questions exception, what's the basis for that? Where is that coming from? Is it predictable how it's applied? And so that's why I think, okay, well, if we were to step back and just from ground zero think, what should the doctrine have been and how could we have approached it? Well, here are my thoughts on that. So, we look at what the basis and source of rules of interpretation might be, and to my mind, there are two bases over here that you would at least primarily turn to. The first is the Constitution, and then the second is the Administrative Procedure Act, right? So we can start with the Constitution first, and this is actually an issue that has been quite prominent in concurrences and dissents over the past couple of years, where folks have pointed to Article 3 of the Constitution that vests the judicial power in Article 3 courts, and folks have said, Marbury versus Madison said it's the province of the judiciary to say what the law is. So if we take all that together, Chevron seems inconsistent with that notion of the judicial power. And so, I have some sympathies for that in some domains, but I have to say there's a major important wrinkle, and this was something that Justice Scalia had spotted and put in some of his early concurrences and dissents in this area, and that is that much of judicial review in the early republic over the course of the 19th century occurred through what we would know as the writ of mandamus. And so the way in which you would get executive actors to obey statutory law was by suing them for a writ of mandamus. And for people in the room, I'm sure we're just all familiar with that from normal appellate practice. And the writ of mandamus carries a deferential standard of review, which in fact was applied in some cases when I say some cases, a lot of cases, including Supreme Court cases, through the course of the early republic. And there's a case, the kind of famous case of this era is Decatur versus Paulding. This is the Decatur of Decatur, Illinois, Stephen Decatur, the naval war hero, which is decided by the Supreme Court in 1840. And it says that, in a nutshell, the mandamus standard requires a deferential standard of review with respect to legal interpretation. And what I think is kind of interesting about this whole set of questions is that we have this dispute in the context of the Chevron doctrine, but here the very same dispute is occurring in the Taney Court. That would be, this is the switch over from the Marshall to the Taney Court circa 1840, in the context of what's the appropriate standard of review under the mandamus writ. So it's kind of interesting to see it from a different perspective, and I think there's some difficulties with saying that Chevron is inconsistent with Article 3. That's the major one. So that leads me, and I'm happy to circle back to that if people are interested in further thoughts on Chevron and Article 3. That leads me to the second source of law, and this is the Administrative Procedure Act. And for those of you who've looked at the Administrative Procedure Act, there's a very short section which sets out the standard of review in Section 706 of the Act. And it says, in a nutshell, the courts shall decide all relevant questions of law and interpret constitutional and statutory provisions. And the court these days is extremely interested in what these terms mean, and much of the briefing in the Kaiser versus Wilkie case revolved around the meaning of these statements as applied to the Auer and Seminole Rock doctrines. I have my own view on what these terms mean, and what I think they mean is that they mean exactly what they say, which is that the best interpretation is that in 1946, Congress enacts the Administrative Procedure Act, and it means to enact some sort of de novo review subject to ordinary rules of legal interpretation. So those would be the ordinary canons of construction that we would apply for legal interpretation of all documents. And so there's a way in which, if you just read the language, it says interpret constitutional and statutory provisions. I look at that and I'm saying, Congress is telling us to do statutory and constitutional interpretation more or less the same way. And then here's the footnote on that point, the little footnote, which is that, does that mean that there's no role for executive interpretations of documents in legal interpretation? And I think the answer to that is no, not at all. And if you just think of analogies in constitutional law, there is, in fact, a role for executive interpretation in construing the Constitution. And the example that I like to use to illustrate this point, it's actually a case that the Solicitor General had argued in private practice. It's the recess appointments case, Noel Canning, in which the court is trying to figure out what the term recess means. And one of the methods that it uses to figure that out is by looking at Attorney General opinions that were written in 1868. Now, is this Chevron deference? Of course not. It's not Chevron deference as such. But why is the court looking at 1868 Attorney General opinions in order to determine what the term recess means? It's because, at least in my view, I welcome anyone's thoughts. In ordinary constitutional interpretation, we have a canon of construction that tells the court to, you can say the word defer if you like, to political actors' interpretations that were roughly contemporaneous with the enactment of the Constitution, or that provide evidence of a customary practice that develops under the constitutional scheme. And it's exactly the same set of interpretive principles that used to apply to statutory interpretation. And I'll just end with this point, Justice DeWine, which is that in Chevron itself, one of the ways in which the court justifies the rule that it's announcing is through a footnote. It's footnote 14 in the opinion, in which the court cites a whole string of opinions that it says, well, these support the outcome that we're establishing in the case, the rule of deference that we're announcing. And if you look at those cases, they're essentially applying a Noel Canning style interpretive approach to statutes. And so the earliest one is this 1827 opinion, Edwards-Lacy versus Darby, and the court in that case is saying something along the lines of, well, there's a custom that is developed pursuant to the statutory provision over the course of time, and so we're not in a position to disturb the custom. What's useful, I think, about thinking of the world this way is that ultimately when I think about what my own views are in a nutshell, they are that, as the APA says, constitutional and statutory interpretation should just be done subject to the same rules of interpretation. And it's a 20th century phenomenon that we've developed these different parallel bodies of law for statutes, regulations, and the Constitution. But there's no reason for that, and it adds unnecessary complexity to this whole scheme of interpretation that's so important to our political and judicial system.
Thank you, thank you, Professor. Professor Walker, that's a little the past. You want to
I
tell
guess
what's going
I'll
on
hit
now
the
in the
present.
courts?
I almost want to skip to the future because
I
I don't think
That's
that I don't think my other co-panelists are on the same page on Chevron's origins, foundations, and the like. But I'm so happy to be here. If you haven't read, especially if you're a judge thinking about Chevron and you haven't read Aditya's Yale Law Journal article that sets forth the origins, you should read it. You should cite it often. It's a very, very, very well executed piece. You're already citing Kristen's stuff, so I don't need to give any more kind of. But this piece in the Yale Law Journal that Aditya's kind of today giving you a little bit of a preview of is really a foundational understanding as we try to rethink Chevron deference. And I say that because over the last 6, 7, 8 years, especially during the second term of the Obama administration, you've seen a rise of Chevron skeptics. They're largely on the right, a combination of misfits of conservatives and libertarians. There's some on the left as well that aren't super excited about Chevron deference, but largely on the right. And we've seen these arguments perhaps featured most prominently at the Supreme Court for the first time by Justice Thomas in his Michigan versus EPA concurrence. And then you also, if you follow the Gorsuch confirmation, he has an immigration opinion before the 10th Circuit. Now Justice Kavanaugh has a Harvard Law Review book review where he also criticizes Chevron deference. It seems if you want a judicial appointment in the Trump administration, you've got to have something on the record criticizing Chevron deference. And as Aditya mentioned, when I think of what the criticisms are, there are kind of two pillars. One is the one that Aditya mentioned, the Article 3 concern, right? That this is substituting the role of courts to say what the law is. Justice Thomas has said that. Justice Gorsuch, I think, said it in a little bit more detail in his 10th Circuit opinion. Even Justice Kennedy, in one of his last opinions on the court, joined that call. And that argument is just this idea that what's happening is that Congress is shifting that power away from courts, and the court should be deciding questions of law. I think there's some problems with that argument as straight up constitutional. Like, as we teach administrative law, courts are still deciding whether there's ambiguity or not. But I do buy into some of the arguments that I think Justice Kennedy was expressing in his final opinion that, well, if we look at how the lower courts apply Chevron deference, having just read 11 years of every single circuit court decision that cites Chevron deference, there's a lot of sloppiness there. Or in other words, as one D.C. Circuit judge said when he was first appointed to the D.C. Circuit, he was really worried about cases, and one of his colleagues said, don't worry. Chevron deference, right? You don't have to worry. Agency always wins. And maybe that's what we're getting at. Maybe it's not, if it's faithfully applied, if there's a searching review, which I think is what Justice Gorsuch has really been pushing since he's been on the court, a really searching step one, then you might get around that problem. The second problem that Justice Thomas and others have raised is an Article 1 problem, or in other words, that Congress is, because of Chevron deference, is over-delegating to federal agencies. If you didn't have Chevron deference, the argument goes, you would have the Congress being more careful about how they delegate, because who would decide it if the agencies don't? It would be courts. And so the idea there is that this encourages over-delegation. I'm not I don't think that's all the way there as a matter of constitutional interpretation. I think that seems like a non-delegation problem. We should be having a panel about non-delegation and not about Chevron deference. But I do, again, understand if your ultimate goal is to reconsider Chevron deference as a matter of interpreting the Administrative Procedure Act, both of those arguments carry some weight. Or in other words, even if you don't buy the argument that it's unconstitutional to have a world with Chevron deference, you could buy the argument that it doesn't make sense as a matter of statutory interpretation of interpreting the APA, that the doctrine is doing more harm than good, right? And I think that's kind of where the court will likely go if it decides to get rid of Chevron deference. I've thrown a third argument that I think only Judge Jordan's bought, or at least I don't know if he bought it, he gave me a footnote on it, but that maybe there's an Article 2 problem. I spent a lot of time interviewing and surveying agency officials, and it turns out that agencies play a substantial role in drafting the statutes that they administer. And that could be problematic if what you care about is a separation of functions, right? It might be problematic in your view to have an agency draft the statute that gives them the power to ultimately interpret the statute and implement it. And so you could have some of the same concerns, although not to the same degree that we have with our deference. I want to back up with my last couple of minutes and just say, does this even matter? The legal realists in the room, which there probably aren't many, but maybe there are, would say, well, no, courts are just going to decide how they want to decide, and then they'll backfill it with Chevron or not. And Kent Barnett at Georgia and I spent 3 years building this data set, of 11 years of every circuit court decision that deals with Chevron. And my first answer is that if what you care about is circuit courts, it sure seems like Chevron matters a lot. So in our data set of about 1,600 cases, agencies won almost 80% of the time when Chevron was applied, 40% of the time when the court expressly refused to apply Chevron. If you look at, if they applied Skidmore, they refused to decide what deference document to apply. It's somewhere in between there. But if you just look at cases where Chevron applies and where it doesn't apply, there's a 25 percentage point difference. We later did a little bit more sophisticated work. That's just your descriptive, where we tried to control for different variables, like the ideology of the panel, the ideology of the agency interpretation, the subject matter. And you still see that Chevron plays a very, very powerful constraining role on how courts interpret statutes when the agencies interpret them first. So if what you care about is circuit courts, which I think is what we should care about, we focus way too much in the U.S. Supreme Court that here's 60-something odd cases a year, maybe 3 Chevron cases. The circuit courts are doing the bulk of the work. Then you should really care about this debate about Chevron. You should also care about it. I spent a year interviewing and surveying agency rule drafters, and I asked them about all the canons of interpretation they use when they're interpreting statutes and drafting rules, and the big winner was Chevron. That I think 94 or 95% of agency rule drafters said they know what Chevron is and they apply it. They think about it when they're drafting rules. My occasional co-author, Aaron Nilsson, had a blog post saying, who are those other 5 or 6% that don't think about Chevron? And I think he's right. What is going on here, right? I asked questions, well, how do you use Chevron? And the evidence wasn't quite as strong, but 4 in 10 said that they think the agency is more aggressive when Chevron applies than when it doesn't. In other words, Chevron matters, I think, at the agency level. If they know they're going to get deference, they're going to approach their statutory interpretive efforts more aggressively, might frame that as less faithfully to the most natural reading of the statute. I've got a lot of litigants in the room. I don't think I have to tell you that when you have a very deferential standard of review, you're likely going to tell your clients not to challenge certain things, right? And so it would also change the role of litigation. And then lastly, and I'll end on kind of this idea, is what will it do to Congress, right? I guess my problem with Chevron deference, or I guess a better way to reframe that is, I would be less concerned about Chevron deference if we had a functioning Congress. If we had a Congress that was regularly legislating, that was revisiting statutes to govern agencies, that was doing proper oversight of agencies in anticipating of re-legislating, not just, I wouldn't have as big a problem with Chevron. It would allow the agencies to be more responsive, to be more controlled by politically accountable branches. And I think that's really something, I don't know what the answer is. I think this would encourage Congress to start legislating more. I'm not that naive, but a few bad judicial decisions might encourage Congress to kind of get up there. So that's kind of the present state of Chevron. I think it matters an awful lot. I think these are debates we need to have. I think there are lots of costs and benefits on both sides, and I can talk later about, if we want, in the Q&A, that I think that some in this room that might be more judicially conservative in the sense that they view the role of courts to defer to political branches, that one huge benefit of Chevron deference is that you're going to have more. The judges are going to be less political. Their policy preferences are going to play less of a role. But it is a big debate that we need to have. And the entree is our deference, which I hope we talk a little bit more about in the Q&A.
Professor Hickman, why don't you take us into the future now?
Sure. So I have to actually start with a disclaimer. So I'm currently serving as special advisor to the Office of Information and Regulatory Affairs. So they make me do this little disclaimer where my views are only my own. I'm not here representing OIRA or OMB or the White House or the federal government. I'm here in my professorial capacity, and so these ideas are purely mine. And I'm going to start off by talking about Kaiser versus Wilkie. I promise I will get to Chevron. I love Chevron as a topic. But I think there's some interesting parallels, and maybe we can see foreshadowed to some extent what will happen with Chevron by looking at what is currently happening with Kaiser versus Wilkie. So did you mention the hour standard, defer to agency interpretations of agency regulations. To be precise, the Seminole Rock or hour standard says that courts should give agency interpretations controlling weight unless those interpretations are plainly erroneous or inconsistent with the regulation that's being interpreted. Now, for many years, those words were taken fairly literally. There have been some empirical studies that suggest that up to 90% of cases involving agency interpretations of agency regulations were decided in favor of the agencies, at least giving some credence to Aditya's preference for fairly simple rules. Hour was applied like a fairly simple rule. Unless it's plainly erroneous or inconsistent with the regulation, defer to the agency. More recently, not starting with Christopher versus SmithKline Beecham, which was decided around 2012 or 2013, but that was, I think, the case that really brought things to something of a head in this regard. We've seen a complexification, or what I call the Chevronization, if you will, of Hour or Seminole Rock, where we've started imposing limitations on our scope. We've started talking about our deference as only applying when the regulation in question is ambiguous, employing some tools of interpretation for purposes of evaluating ambiguity in regulatory text. We've started asking whether the agency's interpretation of its regulation is reasonable. In fact, at the recent oral argument in Kaiser versus Wilkie, Justice Ginsburg put Hour exactly that way. Well, we only defer under Hour if the regulation is ambiguous and the agency's interpretation is reasonable, right? That sounds a lot like Chevron. In fact, at oral argument, I would suggest that if there's anything that's going to save Hour, honestly, it's the complexification or Chevronization of Hour. Largely because once you start complexifying it, then you end up with less deference. There's been another empirical study looking at the application of Hour post Christopher versus SmithKline Beecham and finding substantially lower deference rates under Hour than you saw before that decision. In the oral argument in Kaiser versus Wilkie, you had a big discussion too about stare decisis and the extent to which stare decisis ought to control the outcome, at least with regard to whether or not we're going to overturn Seminole Rock and Hour, with the concern being that if we overturn Seminole Rock or Hour, we're going to undermine the many, many court decisions in which the court purported to apply Seminole Rock and Hour in reaching its outcome. To some extent, how you think about Seminole Rock and Hour, and frankly how you think about Chevron too, comes down to whether you perceive the doctrine as imposing a rule of decision or whether you think of it as counseling a standard of review. With people who follow the standard of review camp, well, Justice Frankfurter, as far back as a case called Universal Camera in the 1950s, talked about standards of review as evoking moods, suggesting an attitude that courts ought to have in evaluating whatever question happens to be before them. That's a little bit of a different approach than if you think of a doctrine as imposing a rule of decision. And you see a little bit filtered through the oral argument in Kaiser versus Wilkie of this strain of argument as well. Is Hour or Seminole Rock a standard of review, or is it a rule of decision? I don't know how the court's going to come out, but I will suggest that in the event that we don't overturn Hour or Seminole Rock, the direction that Hour and Seminole Rock are headed is this complexification of the doctrine, which means it will be applied less often. And when it is applied, it will be applied in a manner that involves greater judicial scrutiny than perhaps we saw before Christopher versus SmithKline Beecham. Let me turn to Chevron. You see a lot of parallels here. As everybody knows, and as I already mentioned, Chevron talks about asking first whether the meaning of the statute is clear, because if we can discern from the statute the clearly expressed intent of Congress, that's the end of the inquiry, because courts and agencies alike must defer to must follow the clearly expressed intent of Congress. It's only when we decide the meaning of the statute is ambiguous that we move on to Chevron step 2 and ask whether the agency's interpretation is a reasonable one. Aditya is absolutely right that over time, what may have started out as seeming like a fairly simple rule, defer to agency interpretations of statutes that they administer, has become complexified as well, not only as we've evaluated exactly what tools ought to be brought to bear at Chevron step 1, but also as we've evaluated exactly what do we mean by reasonable or permissible at Chevron step 2. Is that a purely textual inquiry? Well, these days, especially since cases like Judah Lang versus Holder and Encino Motor Cars in recent years, the courts made clear it's not enough to be textually permissible, but the agency needs to provide some explanation for why it's chosen reasonable interpretation A instead of reasonable interpretation B. Moreover, as Aditya correctly points out, we've established various doctrines limiting when Chevron applies at all. I tend to think of Chevron as a standard of review rather than as a rule of decision for all of its binding rhetoric between the Meade steps and Chevron step 1 and Chevron step 2 that incorporates a requirement of a reasoned explanation. You go through an awful lot of analysis before you ever get to deference, but there does come a point, and here Justice DeWine stole my thunder just a little bit, where you cross over from traditional interpretation to policymaking and the exercise of policymaking discretion. The fact of the matter is, in our contemporary administrative state, Congress has delegated a tremendous amount of policymaking discretion to agencies. And the reason why we ended up with Chevron in the first place was a recognition that at some point in time, all the traditional tools of statutory interpretation don't answer the question. You reach a point where you are in the realm of policymaking. With Chevron, courts have a tool to say, the reason we're deciding the case the way that we're deciding it is because we think of this case as falling in that policymaking realm. And because of that, the role of judges is not policymaking. That's more properly a role for the political branches, in this case, namely the executive branch, and Congress wanted it that way when Congress gave the agency that kind of policy-making discretion, coupled with rule-making power, for example. If we got rid of Chevron, we're not going to get rid of that kind of delegation of policy-making discretion. Instead, all we do is we invite judges to obfuscate the reason for their decision-making, or we invite them to engage in policy-making, neither of which I see as being particularly attractive. Judges who want to avoid entering into the policy-making sphere, I think, will still defer to agency interpretations of law. It's just instead of putting their deference in Chevron-like terms, they will simply adopt whatever argument the agency has advanced as supporting its action. Alternatively, you'll have judges engaging in naked policymaking, which I don't think any of us want. So I like Chevron because I think of Chevron as allowing for transparency in judicial decision-making, given our contemporary realities. Would I like to see a revisitation of the non-delegation doctrine? Sure. And maybe we'll get that with the Gundy case that's being decided in front of the Supreme Court right now. But that's a really different question. So I guess to the people who are opposed to Chevron, I would suggest be careful what you wish for, because you might not like the alternatives.
I think that's a good transition to kind of the question I'm going to put to our panel. And I want you to go out on a limb a little bit here. 5 years from now, what is going to be the state of administrative deference in federal courts? Are we going to have Chevron? Are we going to have Auer? If not, what's going to replace them? And will that make any difference to the size of the administrative state? So kind of a two-part question. Whoever wants to kick it off.
Everybody's looking at me. Well, I hate Supreme Court prognostication because I'm not very good at it.
And don't,
However, I'll go out on a limb. I actually think, from looking at the oral argument transcript, whereas before Kaiser versus Wilkie was argued, I would have said I thought that Kaiser was cooked. I thought that Auer was cooked. I'm a little bit more inclined to think that Auer may survive. And if Auer survives, then I think Chevron's certainly going to survive. But again, what I think you're going to see with both doctrines is less deference under those doctrines as the courts more robustly, in the Chevron context, apply Meade, come up with additional limitations on Chevron's scope, apply Chevron Step 1 more robustly, apply a more robust version of Chevron Step 2. Correspondingly with Auer, with its complexification, I think you will see courts deferring less readily under Auer, and under the category of limitations on Auer that might be described as limiting Auer's scope in favor of Skidmore, you'll see more often Skidmore being applied, and thus less deference as well.
Yeah, I think my thoughts are similar. I was probably more bullish on Auer, at least for going to Skidmore before argument than after argument. But you never know. I mean, I think in the backdrop, I think there is a really serious stare decisis question that Justice Kagan really hit on hard, that the briefs have not dealt with adequately, and I don't think the courts really grappled too much with that. On the Chevron front, I mean, you have 3 justices that I think are willing already on the record to most likely get rid of Chevron, but you don't have more than that. And so what will you have instead? One, I think you're going to continue to see a narrowing of Step 1. Justice Gorsuch put it best in a case last term. He said, looking at a statute to me, looked pretty ambiguous. He's like, agency loses Step 1 because it's clear enough. Clear enough isn't ambiguous in my mind. That's something else. And I think you're going to see that more moving towards a clear enough Step 1 standard. And that matters because in our data set of the circuit courts, if the court decides the question at Step 1 and decides the statute's unambiguous, the agency wins about 40% of the time. If they get to Step 2, the agency wins almost 95% of the time. In other words, there are only 51 cases in 11 years in the circuit courts where an agency lost at Step 2. And so Justice Gorsuch is rightly kind of zeroing in on one area where I think you're going to see a continuing narrowing. With respect to Step 0, which we haven't talked that much about at all, I think that's kind of, in my mind, the Chief Justice's approach is to push more questions, more ambiguities off the plate of the agency and ask, well, obviously ask, as he famously did in King v. Burwell, is this, a major question. Do we really think that agency, that Congress would have given an agency that major question? But I think you might also see him expanding more of the second part of King v. Burwell, where he said, do we really think that Congress would have given that question to that agency? Does that agency have the expertise to do it or not? And I think there's probably enough votes to continue to expand that on the court today. So I'm not predicting either doctrine is going to go away, but at least in the next 5 years. But you're going to continue to see this narrowing. The other problem, I'll just end on this with Auer, you got to have a government that asks for deference. At least I think you have to have a government that asks for deference. Maybe Adisha will disagree with me. This administration isn't asking for Auer deference. I haven't found one case where they're asking for Auer deference. And even now they're saying they're not asking for Chevron deference and expressly saying we're waiving Chevron deference. And so you got to have a government that's asking for it in order to have courts tee it up. Do you disagree, Aditya, with that? Or I'm curious to see that. Can a government waive the argument? Can a party continue to assert it? Or
I know people have written about this, and I haven't thought long and hard about that particular issue. Let me just say a few quick words about the Kaiser Wilkie case and then about Chevron. And so Kaiser versus Wilkie case, what just strikes me about this case, and I wonder if people have the same reaction, is the seemingly high stakes about the structure of administrative law and the actual vanishingly small, thin margin between the law as it currently is and the articulated positions of the two parties. And so if you think about the law as it currently is, Kristen told us the major case that currently is the governing perspective on is the Christopher Smith Klein Beecham case from 2012. And what that says, in a nutshell, to be just somewhat imprecise about it, is that the way in which you apply is through this multi-factor lens, and you look at how consistent the agency's been, considerations of fair notice, things of that nature, and determining whether you apply this doctrine and give deference under the Auer and Seminole Rock decisions. All right, so that's the law as it currently is. Then we have the petitioners who say, that's a bad rule. And they say, well, we got to eliminate that rule, and our fallback option is what has come to be known as Skidmore deference. And this is always one of my pet peeves about this area. There are all these terms for different types of doctrines that really seem to be saying the same thing, quite frankly. But Skidmore deference is the multi-factor approach to judicial deference, which is just take everything into account and figure out whether the agency has the power to persuade. And it's hard to see exactly what the daylight is between the Christopher case and the Skidmore case. Perhaps there is some. I'm not saying there isn't. It's just a thin sliver of daylight. And then we look at the government's position, which is that Auer and Seminole Rock ought to be retained, but viewed through the lens of a robust multi-factor approach. And then the government says, here are the factors you ought to look at. And I think, well, how's that different from the petitioner or the pre-existing law? And Justice Kagan, in fact, brought this up at the argument where she said, well, there's actually an adversity issue over here where everybody seems to be kind of saying the same thing, even though it's being articulated in a different manner. So that's just a thought about the Kaiser versus Wilkie case in particular. It'll be interesting to see how the court resolves it. I agree, I think, with both Chris and Kristen about how the court is likely to approach this in the years to come with all the usual caveats about Supreme Court prognostication. The court seems to be interested in narrowing the scope of these doctrines through a multi-factor approach and through a robust application of what has come to be known as Chevron Step 1. And so I'll just offer two thoughts on that. The first is, that's great, multi-factor approach, that's fine, but what's the justification for each of the factors? I would want to know where are these factors coming from. I mean, if we come up with what has come to be known as the major questions doctrine, what's the predictable articulation of the rule that tells you that here in King versus Burwell, Chevron will not be applied, and in some other case it will be applied. So that's sort of my thought on the multi-factor approach generally. And then on the robust application of Chevron Step 1, which is the step at which the courts see whether Congress has spoken directly to a legal issue, my reaction to that is once you make that step extremely robust, it's really hard to see what role these complicated administrative law doctrines are really playing in the world. And what I mean is the bite, to my mind, that Chevron and Auer and cases like that have are those circumstances where a court will say, here's the better interpretation, but we're going to abandon the better interpretation. Here's an alternative permissible interpretation that the agency has put forward that we will adopt as the interpretation of the legal language. And if you are robustly applying all the tools of statutory construction at the Step 1, I take it what you're saying is, here's the better interpretation wins. And if there truly is no better interpretation, then I take it that there's nothing much we can do. I agree with both my co-panelists that at that point you would just say something along the lines to throw out a statute that maybe would be in this vein, would be a statute like this is a statute that's given in the APA report that accompanies the APA in 1946, is the SEC proxy rule statute, which says proxy rules are illegal pursuant to rules and regulations that are promulgated by the SEC. So how do we know what the better interpretation? We don't know. Until the rules and regulations are promulgated, that statute just has no meaning whatsoever. And I agree that under those circumstances, there's just no there's no role for the court to play in terms of interpretation. It's just I don't need Chevron and all these various steps to tell me that. I just know based on like ordinary rules of interpretation.
I want to make one point real quick, just in thinking about this, or actually 2 points. Number one, it's interesting to think about, we talk about a narrowing of Chevron. Justice Scalia described Chevron this way in 1989 as having a very robust Step 1 and as this distinction between policy and law. So it's not really a new conception of Chevron, even if it seems like it. The other thing I want to point out, just in response to one of the things that Adit just said, and this is one of the reasons why I like to think of Chevron as a standard of review, the touchstone for all of this really is one of, did Congress give the agency a special role with respect to this particular issue that's in front of the court? The delegation premise for Chevron has been derided as a fiction. Certainly, I don't think that Congress thinks of standards of review when they delegate authority to agencies. But there's no question that in the contemporary administrative state, Congress has given agencies unique roles with respect to policymaking discretion. That's the touchstone for all of this. It's really easy to get lost in all the arcana of Chevron. How many angels fit on the head of a pin is what it seems like sometimes. But if you step back and just ask that simple question, did Congress give the agency a particular role to play here? That really ends up being sort of, everything else is how do we figure out if Congress gave the agency a special role here? And if Congress did give the agency that special role, has the agency acted reasonably? Anyway.
Before we get to questions, let me just throw out one question for anyone. Anyone wants to take a stab at it. It seems to me we talk about, and you referenced the attack, the assault on Chevron deference, and clearly there's an academic part of that, the Article 3 problems, the purported Article 3 problems, the APA, inconsistent with the APA. But there's also, I think, it's fair to say, probably a political part of that as well. I mean, and certainly you hear that in some of the rhetoric that comes from Washington and folks is that we have this tremendous growth of the administrative state, and if we could get rid of Chevron, we could do something about that. Is that really true? Is that true? Would getting rid of Chevron, getting rid of ARA make any difference to the size of the administrative state? Would it make any difference to the average person who lives in Columbus, Ohio?
Yeah, I'm going to say yeah. I'm not sure if that's actually the right answer, but I'm going to say yeah. And I guess the reason why, I mean, some of this is symbolic, right? I think that it is a symbolic message. I think Chevron has emerged as kind of a champion of deference to the bureaucracy. But I do think it matters, and I think sort of like, well, why are people bringing these challenges? Is it just they didn't like the last 4 years of the Obama administration, or 8 years is a long time to go? Is it real, just pure politics? I think the answer is no. I really do think it gets back to this idea that lawmaking today predominantly happens at federal agencies. Congress is doing very little. Courts play a lesser role. Agencies are cranking out, well, in the last administration,
don't forget state agencies.
Yeah, well, there's that too. Yeah, and that's troubling. I think Congress should be playing a much more involved role in how we're regulated. They should be making decisions, hard decisions, and if they can't make decisions, we shouldn't be regulated. And that's really what I think Chevron's about. It's a symbolic message. Getting rid of Chevron sends a strong message back to Congress that they've got to start legislating again. So, but I'm probably wrong. I mean, if we got rid of it, well, once Kristen will say we can't ever get rid of it. It'll just come up in a different form, and that's fair. I don't think I entirely agree, but it's fair. But I do think there is this kind of idea behind it that's moving it, that we need to reinvigorate Article 1.
Any other comments before we open up for questions?
Well, it's not surprising that I wholeheartedly agree with everything that Chris said except his punchline. He's right that we've turned over most of American governance to an unelected bureaucracy. On the other hand, I just don't see getting rid of Chevron as the solution. Chevron's become the boogeyman for something else entirely. And I feel like, focusing on Chevron risks misdirecting our efforts to getting Congress to act more responsibly and to legislate for itself rather than delegating so much power to agencies. Now, Chris is right about the symbolism, and I don't want to inappropriately minimize the importance of symbolism. I've got a symposium essay on symbolism and separation of powers in the administrative state. Symbolism is very important. And so maybe getting rid of Chevron does have some symbolic merit to it, but if it doesn't make a dime's worth of difference at the end as to how the government actually operates, then I'm not really sure that the symbolic effort really gets us very far.
Can I just add, I do, kind of, as I said before, I think agency officials, having spent a lot of time interviewing and surveying agency, they will act differently with a world without deference, absolutely. They're going to be much more careful, they care a lot about judicial review, about being reversed. They're going to act, I think they will act differently, just as they would if we got rid of qualified immunity, which is a different subject.
Teacher, last word on this?
I actually tend to agree with Kristen's punchline more than Chris's punchline on this particular question, and that is, so 2-1. I guess you can take that home. So that's how the panel votes. No, what I mean is I'm not sure that size and scope of the administrative state is the right way to approach this particular doctrine. And the way that I think about it is what are the neutral principles of interpretation? And the neutral principles of interpretation ought to apply in every single case. And that's the way in which, you know, somebody like Mr. Kaiser is able to figure out whether his claim for benefits is going to be agreed to or denied in a given case. And if you start to play around with it on the margins for policy reasons or for other reasons that you think are a good idea or a bad idea, then it just makes the whole system harder to navigate for people in the position of Mr. Kaiser.
Kind of follow up on that, Adisha. If Congress passed a statute that amended Section 706 of the APA and codified Auer and Chevron, is your argument done? Or do you still have a constitutional argument behind kind of your argument?
That's actually, a really good question, and I think a very challenging one. And so I mentioned that, you know, there are these two sources of law that we could look to, one of which is the text of the statute, the APA. The second is Article 3, and we've seen both of those developed in litigation recently. And I said, well, there's a caveat to the Article 3 issue, and the caveat to the Article 3 issue is that there was, in fact, a substantial body of litigation that occurred pursuant to the writ of mandamus and that did carry a deferential standard. So you need to explain those cases in order to make an Article 3 style argument. And I think there's actually a bit of an explanation, but it requires further development, which I've yet to do. I'm curious to hear whether people have thoughts on this, but there's some judicial review that occurs through the writ of mandamus, and there's some judicial review that occurs through common law suits that are brought against officers in order to enforce statutory or constitutional provisions. And the common law cases are decided de novo. Statutes are interpreted de novo in the common law cases. The mandamus cases have this deferential standard of review. And if we were to read the Constitution against the backdrop of the common law, you could say that distinction is baked into the system. And there is, in fact, a separate line of cases in which the Supreme Court says that distinction is baked into the system. It's just not this line of cases. It's the public rights, private rights line of cases involving whether you can have an administrative agency make a determination that then is binding. This is actually a very closely related doctrine on an Article 3 court ultimately. So this came up most recently in that oil states case involving the what's known as the PTAB. And so that line of cases involving a distinction that has to be based on essentially this, which is were you given a private right through some sort of common law lawsuit, or should we conceive of the type of action you're bringing as a public right? I think that distinction maps onto the way in which courts, during the course of that time when mandamus suits were quite common, viewed this doctrine of judicial deference. So that's a first cut at it.
Okay. How about questions from the audience?
Hello. I may have planted a few questioners just to, so now that I've lost 2-1 apparently.
Yeah, thank you everyone so much for a very informative panel. We've talked a little bit about the political aspects of this, how we've moved from government by consent to government by expertise, and we've obviously talked a lot about the legal aspects of administrative law here. What about the economic angle to a lot of this? It seems that one of the functions of an administrative state is that it creates a regulatory framework that protects market incumbents that then have a vested sort of interest on some level with maintaining a status quo where the agencies, rather than an unpredictable Congress, makes the rules of the road that govern their particular industry, and many revolving doors established between the companies, law firms, and agencies that actually govern a particular industry. To what extent would changing Chevron rules have any effect on that aspect? It seems like if there is less expected deference from a court, you introduce an element of now whether or not you have good legal arguments reinvigorates sort of the political laws that created that agency in the first place. And so it would create less of a set of market incumbents that defend an existing administrative state to their benefit if they know that that regime could be disrupted by a lawsuit.
What do you think?
So my reaction is it's entirely plausible as a thesis, and I take it the point is that it's easier to capture specialists who are amenable to political pressure, namely agency officials. It's harder to capture generalists who have life tenure, and so that's in fact why we have the system of separation of powers that we do. That said, I mean, I take it what your thesis is. It's like an empirical prediction about how the world operates, and I don't know the answer to that. It's a hard prediction to substantiate one way or the other. I mean, maybe one way we could try this out, and it's just as DeWine suggested, different states have different approaches to exactly this doctrine, and it's not the case that across the board the Chevron doctrine is followed in all its nuances in different states. And it'd be interesting to me, I'm not sure anyone's ever done this, to see whether states come out differently in terms of their political organization as a result of the rules of interpretation being different. Just some thoughts.
So I mean, somewhat along the same lines. I mean, Chevron itself was a deregulatory decision, right? It was allowing the Reagan administration to redo some rules that made it hard for companies to deal with development in light of clean air. And what's been interesting with Chevron, like in our data set, we didn't expect to find this because when Justice Stevens, wrote the Chevron decision, he seemed to say that politics wouldn't matter, like that, if it's a change in position, just because it's a change in administration, we don't look to that. Like, we only look at whether it's reasonable. But in our data set, circuit courts were much more likely to strike down agency, interpretations that were not longstanding, that were changes in position. And I think the Supreme Court has gotten very interested, too, in forcing agencies to give reasons other than we had an election in order to change something. And I say that because originally I think Chevron was viewed as a tool of flexibility for a new elected official to change the regulatory structure. I think that's much less so today than it was envisioned back in 1984.
Just a question?
Yeah, thank you, and thanks again for coming. My question goes to the stare decisis effect of doctrines like Chevron and Auer and Seminole Rock. And it's really a fundamental question. Why should they be entitled to stare decisis effect at all? So the Supreme Court decides a case like Heller, and all 9 justices use originalism. That doesn't mean going forward we have a Heller doctrine where lower courts must apply originalism to interpret the Constitution. The same goes with textualism. If the Supreme Court says we're going to use textualism to decide a case, that doesn't mean all lower courts are bound to use textualism, unfortunately. So my question is, why isn't Chevron deference, that doctrine of deference, or Auer like that, as opposed to like a rule of decision that, of course, would be entitled to strong form stare decisis effect?
Well, it's kind of a third category, right? I described
Exactly.
Chevron as a standard of review, Auer as well as a standard of review as opposed to a rule of decision, and you're effectively describing them as like canons of construction.
Right.
it's interesting you asked the question because I'm actually working with a student right now on an article on this very topic. What is Chevron? How do we categorize it? And what are the implications for things like stare decisis? And I suppose, I don't think we have a clear answer to the question of how we should categorize Chevron as to whether it's a canon of construction or a rule of decision or a standard of review. I personally think it's a standard of review, at which point I think standards of review are eligible for the same sort of stare decisis effect as rules of decision are. Canons of construction clearly aren't. So how do you characterize Chevron? Interestingly, harking back to stare decisis, I think the court has characterized it more often than not as a standard of review rather than as a canon of construction. But if you're right that we should think of it as a canon of construction, then it wouldn't be eligible for the same stare decisis effect. We just have to decide how we categorize it. I don't know whether the court will ever do that or not, but I'm hoping to make them think about it.
So I would just, I guess my thought was more not whether it's whether it's a statutory interpretation of the APA or not. I mean, this is one reason why I ultimately just couldn't join in the anti-hour brace in Kaiser, because I was still struggling through my mind. If this is an interpretation of the APA, not only do we have stare decisis, we have statutory stare decisis, which I think is an important tool to respect Congress. And so I don't know. I guess if I'm sitting here today, I would say I view Auer and Chevron as interpreting Section 706 of the APA, which makes it an even more uphill climb for me. Randy Kozel has a great new article that just came out in the Texas Law Review on this, where he comes to the opposite conclusion and says that these are areas where strong statutory stare decisis shouldn't apply. I'll be honest, I've read it maybe 3 or 4 times, and Randy's brilliant. I'm just not persuaded.
Yeah, I think it's an interesting thought. I think, whether we should think of the world, I suppose here's the argument on both sides, whether we should think of the world as canons of construction, their application don't get stare decisis, rules of the decision do get stare decisis. That's the dichotomy. Or alternatively, should we just think of more broadly, who's relied on this? Do we think of all the kinds of functional considerations that might go into, are people relying on this? Who's relied on it? So I think that's one way to think of your question, the stare decisis point. Is it the more, we're going to draw a clean line between 2 different types of things that are said in opinions, or ask in some ways the question that underlies the stare decisis inquiry generally. I guess my reaction to the stare decisis objections to, this circles back in a way to some of the things that I said at the very beginning, and that is that I'm not entirely sure what this doctrine means. When people say it's like Chevron should have stare decisis weight or Auer should, it's just not clear to me what that means. What are the rules? If you were to say in a nutshell, what are the rules? And I think the way I heard my co-panelists, it seems as though the rules right now and going forward are going to be some sort of multi-factor approach, in which case this isn't in some ways a real stare decisis issue. This is a explain to me what factors you're using Supreme Court issue. That's, I think, the way that I would characterize my own thoughts. And in some ways, it's kind of like the Kaiser versus Wilkie case. If all of a sudden the Supreme Court were to say something along the lines of Auer and Seminole Rock are overruled in this case, and now what we're going to do is apply the Skidmore line of cases and Skidmore deference, but we're going to apply it really robustly. That's really functionally the same thing. We're reaching the same result in different terminologies being used, and I just think we shouldn't get wrapped up in the terminology about Chevron being overruled. We should ask for, explain your method of interpretation as a court, and I think that's what's important.
All right, we have 6 minutes and 2 questions left, so I guess we're in the lightning round now for everybody.
Brief comment and then a question. So the panel talked a little bit about whether Chevron deference could be waived, and the DC Circuit decided this week in the bump stock litigation that, in that case, in fact, the government had not just not asked for Chevron, they had said, if you decide that this rule turns on Chevron, we'd rather have no rule at all than to have a rule that's upheld on the basis of Chevron. And the DC Circuit said that you cannot waive Chevron. So that's an interesting new development. My question is mostly to Professor Hickman. And you were talking about one of the consequences of getting rid of Chevron would be that judges engage in more policy making, because there are some questions that cases present where legal interpretive tools don't get you all the way. And Cass Sunstein and Lord Solem have a piece recently where they talk about the difference between interpretation and construction. They say interpretation is where semantic tools, legal tools can get you to an answer, and that maybe Chevron should apply differently in that class of cases than classes that are more policy questions. And do you have thoughts on that? Do you think that's a helpful distinction at all? How you tell the difference?
I'm aware of the Sunstein and Solem article, and I'm also aware of Larry's long-time characterization in the constitutional context of a distinction between interpretation and construction. I haven't really sat down and thought about their precise framing vis-a-vis what I'm talking about, but at least from my understanding of their distinction, it's very similar to what I described and what Justice Scalia, for that matter, described back in 1989 in his Duke Law Journal article and talking about Chevron and talking about different kinds of statutory interpretation questions, those where you could find answers using traditional tools, where Congress, spoke in terms that lent themselves to that kind of judicial inquiry, and then other kinds of questions that are more policy-oriented that just don't lend themselves to that kind of resolution. I do want to say something really quickly about the Chevron waiver point, because that's come up a couple of times now. There is at least arguably an emerging circuit split on whether or not an agency can waive Chevron. The bump stock case that came down last week, I think finally, the DC Circuit had kind of inadvertently stumbled into suggesting that you could waive Chevron, and then came out much more squarely the other way in the bump stock case. But in the meantime, there are other circuits that are either stumbling or trying to grapple with the same question. To some extent, there was an 11th Circuit case, and I'm blanking on the name right now, that laid out what it saw as an emerging circuit split on the issue, and suggested that part of the issue came down to whether you think about Chevron as a rule of decision or as a standard of review, because of course standards of review can be waived, or can't be waived, because the court, not the agency, decides what the standard of review is, whereas a more substantive argument or rule of decision kind of legal inquiry can be waived. And so, maybe that will be the lens through which we get to the last questioner's point about how we characterize Chevron.
All right, we have one more question. Time for one more question.
I'd like to thank the panel for coming to speak on a topic that I'm extremely interested in. So Justice Rehnquist, in his State Farm concurrence, said that when an agency changes their mind on a policy decision, that there should be a more deferential review when it reflects the change in administration or the president himself, or the president's policies, as well as in Ilana Kagan's presidential administration law review article talking about how Chevron should probably be more deferential to agency interpretations that reflect presidential policies. Have you noticed this at all in any of your research, and have there been any strong takers on this point?
Yeah, I mean, the circuit courts, that hasn't played out, and that was one of the things I was hoping to be able to show. One of the many things we were trying to test was, is there more deference if it looks like it was a policy decision, change it in policy, and it actually comes out the other way. And I think you're going to see more and more of that. They're going to have to provide good reasons. Other than that, I mean, that's kind of the why am I blanking on the name of what was the Kennedy decision a couple years ago?
Encino Motor Cars?
Yeah, Encino Motor Cars, right, when they come out and say that.
Yeah, no, so there's been a lot of discussion for a long time about Justice Rehnquist's opinion in State Farm, and the notion that, of course, politics drives agency decision-making, and as you have changes in administration, you're going to have changes in policies. The difficulty being, as some people have observed, that we have found ourselves in a situation, in no small part because of Chevron, I think, where with certain issues, interpretive issues with respect to statutes, it's gotten to the point where with every change in administration, we flip back and forth as to what the interpretation is. And the consequence of that is a lot of inconsistency that businesses have to put up with that ends up being really problematic from a rule of law and a perspective, which I think is maybe one of the reasons why, notwithstanding the fact that, of course, politics drives agency decision-making, courts are a little bit wary of giving into that point because of the resulting potential inconsistency in the application of the law over time in ways that in turn undermine the rule of law.
On this last question, I defer to my co-panelists.
Thank you.
Can I get one
Close this out?
unrelated?
Absolutely.
Just one unrelated. So completely unrelated to the panel, but while I have a room of 200 of you, the Portman Brown Judicial Commission is starting back up. Applications, we have at least one opening in the south and at least one opening in the north. Applications are due on April 16th. Happy to chat with any of you. I encourage you, a lot of you, to apply, as well to spread the word. The better pool we have, the better chance we have of getting good people through Brown's side of the commission. So I really encourage you to consider applying. I'm happy to chat afterwards about that.
Well, thank you to our panel. I thought it was a fantastic job. Appreciate the chance to be here.